Okay, awesome. I'm going to go ahead and start. I'm Tracy Gore, in case you don't know, with Infinite Wealth Collective, and that's my partner, Drew Roberts, that was just speaking a minute ago. Today, we're going to present to you an amazing woman that I met in Florida at Beth Azer's Women's Real Estate Investment Summit, which is amazing. I suggest you go if you haven't. Um, Lindsey really impressed me. She gave a class and she was on stage and she gave a lot of valuable information. And so I sought her out when we needed somebody that was experienced in this um, subject. So Lindsey you have a real estate firm and a law firm, right?
Yes, that's correct.
Okay. I'm going to go ahead and let you take over and give the people what they want.
That sounds great. I'll start sharing my screen. And I know I mentioned to you guys before the call, I'm not as adept at Zoom. So please bear with me here for just a minute while I confirm that I know what I'm doing.
Yep.
Or Tracy, can you confirm you guys can see my screen okay?
Yep.
Sounds great. All right. So I'm presenting today on asset protection. As Tracy mentioned, we met, gosh, earlier this year, I think it was January, at an event that was focused on women in real estate in particular. And I was there on behalf of the real estate group that I'm an owner in called Acre Holdings, but I'm also a licensed attorney and do a lot of legal work on top of that in the real estate space. And so I'll give a brief introduction, but I want to first thank Tracy and Drew for thinking of me and reaching out on this topic. It is going to, where the focus of this presentation is on asset protection, but it's from the lens of a limited partner. And so we're going to really be focused on if I'm coming into an investment or my entity is coming into an investment, not as a sponsor entity or a manager entity, but instead as a limited partner who has maybe limited voting rights and things of that nature. What do I do to protect myself down the road? How do I ensure that I'm doing the best that I can to ensure that I'm selecting the right investments and then protecting those investments going forward? I'll spend I think it's a single slide at the very end to talk about if I'm a general partner, how do I do that? And delving into how do we as owners and general partners or sponsor members protect assets would be probably a topic for a different conversation. So like I said, today we're focused on the limited partner side. So like I said, my name is Linzey Erickson. I own a law firm and a real estate firm. The real estate firm that I am part of is specific in hospitality. I was the chief legal officer and president of a large real estate group based in Fargo, North Dakota, which is where I am right now. And I launched with my partners just over 2 years ago now. So we've been together for about 2 years owning our own practice. We own 3 hotels we acquired as existing assets. One is a Marriott brand and two are IHG brand, and IHG, think kind of Holiday Inn Express. They have a bunch of other large hotels as well. We own 2 of those. And we're about to close on our fourth opportunity, which is going to be a development in the hotel space. So we're really excited about that. That closing is scheduled for mid next month. And so we're specifically in the hotel space. That's where my real estate business lies. But as I mentioned, I'm here, I think today as an attorney. And I do a lot of legal work in the investment space. I represent both investments, so the investment entity, as well as investors who are looking at potential deal opportunities. And so I'm coming at it, like I said earlier, from that second lens as what can investors do to ensure that the assets that they're coming into and investing in are going to be protected. I have to caveat before I move on to say I'm not providing legal advice during this presentation. And of course, reach out to me if you have any questions, but also if you're looking at leaping into an investment or have specific legal questions that require formal legal advice, please ensure that you engage an attorney for those. So this is kind of the overarching table of contents of the presentation. We'll spend, I would say, the vast majority of our time talking about due diligence because I believe firmly that the way to protect assets down the road is to do as much work upfront before you ever buy an asset or invest in an investment as you possibly can do to limit your risk. It's when that upfront work by yourself and by the sponsor members, if that upfront work is done quickly or done not in the best way, you're going to have a much more difficult time a year or 2 or 5 years into owning your asset to try to clean up work that should have been done before that closing. It's the best time that you can ensure that you're protecting yourself. So we're going to spend the most amount of time on due diligence and what that looks like for an investor. And then I'll get into just a little bit of kind of structural other items that you should be considering as you're jumping into an investment. And then I'll finish with ongoing monitoring. So like I mentioned, single slide, but we're going to spend a lot of time on this. So maybe Drew, or I can't see the comments very well. If anybody has comments or questions as I go through the details on this slide, please feel free to jump in because I'll be on this slide for a while. I want to start by talking about strategic alignment, which is the second bullet point in the presentation. And what that means is, what are you looking from a business standpoint to get out of any investment that you're going into? So before, I would encourage everybody, before you even begin looking at sponsors, or if you already have certain investments and you're looking at deploying more funds into investments where you're going to be a limited partner, what am I looking to get out of those? You should actually have those written down before you go start seeking or considering investments, because it's very easy to get caught up in kind of the sales pitch that people can give and forget why you're investing. It will make you much more disciplined as you're looking at investments and talking to sponsors and looking at deals if you know exactly what you're trying to get out of it. You don't want to get into the investment and then say, wait a second, they're not paying me a cash return. Well, they might have told you that and you just didn't look, right? And so this piece I would begin to put down, and I propose and recommend that everybody put down, what is your hold period? So just as a round number example, I want to deploy $100,000 into investments. How long are you okay with that money being gone? Is it 3 years? Is it 5 years? Are you okay with a longer term hold where it might be deployed for 10 years before there's a liquidity event and you can get out? So that's the hold period. Do I want a cash return immediately? If you do, then you're probably not looking at a development deal, right? Because in a development deal, you're looking at a pretty long period of time where there's going to be no operations and no cash flow to support any type of cash distribution coming your way. So does that matter to you? Are you willing to take on more risk and wait for some of those returns? Because at the liquidity event, you're going to have a potentially larger return coming back to you. So those are just important things. Do I want cash along the way? Am I okay with less cash along the way, but a really big return of equity and return on a sale? Other things to consider, as I mentioned, the risk tolerance. If it's a new development, that's certainly more risky than something that's an existing asset. And I'm talking here about hard assets, real estate assets that might have cash flow associated with them. You can absolutely be thinking about operating companies and other types of acquisitions that you can do. But if it's existing today, you can look at real financials. You can determine how much cash is going to be coming off of that business based on historical performance. Is that important to you? Or are you okay with something that is distressed and not cash flowing today, but maybe you have the potential for a turnaround and larger returns on the back end? All of those things you should think about before you go seek opportunities to invest your $100,000. So that's the strategic alignment piece. I'll go back then to talk about, once you've determined, here's what I'd like to get out of my funds, and you diversified, maybe some things are long-term hold and some things are faster turn. Maybe some things are going to give you immediate cash and you're okay waiting on others. So you've kind of thought about, on a portfolio basis, what you hope to get out of it from a return standpoint and an investment strategy standpoint. Now you're going to go seek, hey, what can I invest in? That's where the sponsor diligence next comes in. I have had too many law firm clients to count who had a friend of a friend recommend an investment. Their friend knows this person and will vouch for them. They don't have any idea what the investment is. They get in and I get hired not on the front end, but when the whole thing is going up in flames. You have to be willing to delve into sponsor diligence and when I say sponsor, just to be clear, it's the entity or individuals who are putting an investment together to go out and source other people's capital to make the deal work. And so those sponsors are the ones that should know everything soup to nuts about the investment that they're undertaking, and you're trusting them with your funds. And in all likelihood, those are also the individuals who will be managing your entity and investment going forward. So that's the diligence I'm talking about here. You should know what their educational background is. You should know what work they've been doing historically. You should know if they've put together other deals, and if they have, how have those performed? How have they performed against what they told investors in those former deals? How has that looked? And then that personal component can absolutely come into play. But from an objective standpoint, the fact that a friend knows a friend is probably not a box that must be checked in order to ensure that you're protecting yourself. And again, I can give you actually an example because some of the investors that I represent are it's public knowledge. There's a group, a real estate investment group that was based here in North Dakota that went belly up, and they had dozens and dozens of different real estate deals, all of which are in a sort of disarray. And everyone knew the name of this entity in the Midwest. And so no diligence was performed on how the deals that they had put together 2 years ago or 3 years ago or 5 years ago, excuse me, were performing. It was a name that everybody recognized. And so people were just continued to invest because the name was recognizable in the area. A lot of people lost a lot of money with that group. And so navigating that has been critical. Knowing just the name or knowing a friend is not sponsor diligence on its own. Can't stress that enough. One of the other things to consider from a diligence standpoint, after you've considered what the returns are going to potentially look like, what the goals are for that investment, what now you've decided that you trust the sponsor, they're going to be great. Discuss with that individual, with that sponsor, how they plan to report on an ongoing basis. And we'll get into this a little bit more when I talk about the monitoring component going forward, and in the legal document piece. But if the sponsor that you're working with has invested and has other assets under management, they should be able to say, here's the type of information that we provide to investors on an ongoing basis once we get this deal under ownership. Here are the financials that we provide. Here are the reports in our particular industry that are available that we pull and we'll send on to you. Here's how to contact us. If they are trustworthy, the questions that you ask, both about their background as well as about the way that they're going to communicate with you after the deal closes, if they're trustworthy, they're going to be totally fine answering those questions up front. If they begin to hesitate and they're not willing to share information and they're not willing to commit to you on what cadence they're going to be providing information, that should be at the very least a yellow flag for you. Because if they're tentative about whether they're going to provide things and on what cadence they will before they close on the transaction, I'm certain they're not going to they're going to be difficult to find after the transaction has closed, after your money has been deployed, and when you're then stuck just in an asset protection standpoint, there's not a lot that you're going to be able to do. And so feel free to ask those questions. Get somebody like a Tracy or a Drew or whomever to kind of help guide you. Legal counsel, like I said, who can help guide you to ask those questions if you're uncomfortable doing so. But once those funds are deployed, depending on what type of asset you're investing in, they're not coming back to you quickly. And then, of course, probably the most critical piece of any individual investment is looking at that underlying deal. The one thing I'll note Tracy, from your and my time at this event that we attended on behalf of women, there are lots of pockets of all different types of individuals in the US and abroad who are physicians or dentists or accountants or you name it, and have funds to invest but do not have the wherewithal to look at a balance sheet and an income statement and understand what the current financials or what the projections for a given deal mean. And if that is you, please, 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 before you deploy any time or capital, find someone who you trust who can help you to do that. Because all those individuals that I just talked about, of whatever background, age, race, whatever that you might be, you absolutely can dig into people's educational backgrounds. You can have an assessment of, here's the type of return that I would like. And I understand what you're telling me this investment may pay. But in the end, if you're acquiring an existing either asset or business or whatever it is that this investment that you're jumping into is going to purchase, someone with some knowledge of how to read those numbers ought to be reviewing that and giving you some type of feedback on what that looks like. Are the projections that this sponsor is telling you you may make, are those realistic? How much growth has to be achieved in order for the investment to make what the sponsor says it's going to make? Those are the types of things that you cannot overlook. And I will tell you, we have one of the deals, the deal I mentioned at the beginning of this conversation that I'm working on right now is a new development deal in a pocket in Michigan. And when we went out to start seeking investors to come into the deal, we actually had people say, yes, the cash return, of course, doesn't start until we open. So there's a period of time where there isn't going to be a distribution. Everyone fully understands that. By the way, it's worth noting, if you are invested in a development deal that is paying distributions back to you while the development isn't complete, that is a red flag. It's not a yellow flag. It is a red flag because those funds can be coming from nowhere other than someone else's capital. In any event, in this particular deal, we were very clear during the period where we are not open and operating, there will be no cash distribution. And then, of course, it ramps because there's a stabilization period. We did have investors, though, that said 5 years out, this kind of looks too good to be true. So we even had people who were looking at it saying, I'm not sure you can achieve this. And people will even hesitate. Not, hey, I'm concerned about your numbers, but hesitate as in, I'm not sure I want to invest because do you guys know what you're doing? It's that level of questioning. Now, I can tell you in this particular deal, we had 3 different parties confirm our numbers, including the operator who's going to be operating our hotel. But 100%, those are the types of questions that need to be asked. And if you're not adept enough to be reviewing those financials, it's your hard-earned money. And like I said, once it's invested, it's much more difficult to protect. Now is the time to have somebody really vet that. I might pause for just a moment. I went a little bit fast, but does anybody have questions, or Drew, Tracy, is there anything that you guys want to jump in on for that piece?
I would just ask Lindsay, so Tracy and I have used different background checks and things like that, but I guess when it comes to just the overall due diligence, what level do you typically feel comfortable, like, yeah, I want to move forward on this? Like, how deep do you go? Do you look at socials? Like, I'd love to get your perspective on here's how deep I go compared to what everybody else does, kind of thing.
Yeah. So I typically run a report that would show whether somebody's has UCC filings against them or active litigation against them for the sponsor level. So I'm not doing a full background check. I don't need them to sign anything in order for me to do the searches that I just mentioned. Because if somebody has sued them publicly or has sued them, it's public. I can locate that information. I do when I'm engaged on the law firm side to do this type of diligence. I do perform those. I will admit I have, in addition to my own deals that I have with my real estate group that I own Acre Holdings, we also, my partners and I also invest in other things unrelated to our business. And when I do that for myself personally, I'll tell you, or maybe just admit, I typically satisfy myself without going forward with all of those the additional checks. I'd Google search. And gosh, with technology the way that it is right now, AI and everything else, it captures a whole lot. So if somebody doesn't want to go through the process of actually engaging somebody to perform that type of analysis, a Google search is going to find most things.
Awesome.
Yeah, I agree. Chat GPT is your friend.
It is, and they can the algorithms can now reach the far corners of the internet, and
Yes,
so it
you can do
catches
it.
a lot more
You
than
can
it
do a
did
deep
even
dive.
3 or 4
Yeah,
years ago.
amazing.
Yeah.
I don't have any questions, I don't think.
Okay. Then I'm going to jump into legal agreement review, which I'm sure everybody is extremely excited to talk about. But this is a critical, it is a critical piece of your review. And again, this is a step that's occurring before the investment. This, however, while we're performing diligence and you're trying to check off as many boxes as you can to say, okay, I've minimized risk, or at the very least, I understand what my risks are. I know the sponsor, they have a pretty good track record. I've looked at the deal. It looks good. I've been told, or I understand that the projections are reasonable based on historical performance, or however you've come to some conclusion. Now you've told the sponsor, I would like to invest my $100,000. They should give you documentation. It shouldn't be a single page that you sign. It shouldn't even just be an operating agreement that you sign. If you are coming in as a third party and giving your money to somebody else to invest, there should be documentation. Now, what that documentation looks like is different. I would say typically depending on the size of the deal. If you're coming into a very large, for example, blind fund, where the sponsor is saying, I'm raising $100 million of equity to go buy, because it's easy on the top of my head, hotels. The hotels that I buy are going to look like Marriott branded hotels in big cities throughout the US. And here's the price point that we're about going to achieve. You're putting money into a blind pool, so they haven't purchased those assets, nor have they necessarily identified them. You're likely going to get a 200-page, it's called a private placement memorandum, and it will include all kinds of disclosures about the risk of not knowing what type of asset exactly you're going to buy, not knowing what those financials look like. You can't do some of the analysis I talked about, and it's going to be a really big document. There is, of course, the positive of that type of structure is diversification. Within that fund that you're investing in, they're saying they're going to buy with the $100 million, maybe 5 hotels or 10 hotels. So you're going to get diversification within that fund structure. What I'm talking about here on this slide and what I've been focused on are sort of the deal by deal structures where you're coming into an LLC that's buying a particular and identified asset. And in that structure, typically what you should get is the operating agreement, which is basically, I'm investing in entity XYZ, and here's how, and that entity XYZ is going to purchase this asset with the funds that come in. And here's how that entity can make decisions, can make changes, how it's going to pay distributions during the hold period, how it's going to pay distributions at the end of the hold period. All of those things come through in an operating agreement, or some people call it an LLC agreement, assuming you're investing in an LLC. You should also get a term sheet, which should include the typical kind of very high level financial terms. It's basically a synopsis of that operating agreement. And then your subscription agreement is the way that you actually sign your name on the dotted line. You say, I'm investing my $100,000. Here's how much ownership in XYZ LLC I'm going to get, and I'm signing, agreeing to all of the terms that I've reviewed. When you get those documents, it's really easy to say, I'm not a lawyer and I'm just going to sign my name. I've done my diligence. I know the sponsor. I have confidence in all these things, and I'm just going to sign. The reality is, whether by virtue of carelessness or maybe lack of attention to detail, or maybe, hopefully not, fraud, the actual documentation that you get, that you sign, that you receive and sign, doesn't always match the thing that you might have reviewed, the pretty deck that you reviewed that talked about the terms. And the reason I say that is because when I was going to invest personally just 2 months ago, a group who meant absolutely well and was talking to me about, here's the return that we're seeking, here's the return that you get before the sponsor gets anything else, all those things. And they sent me the operating agreement, and it didn't include any of the terms that we talked about. I don't think they meant to do that, but I do believe that there were people who had received it at the same time as me and already signed, even though it was different than the thing that we talked about on the phone call. And so it really is important. You don't necessarily even need an attorney to review those documents. I'm going to give you some high-level things to for sure take a look at as you review those, because it doesn't have to be an experienced in-depth review every time, but there should be some key pieces that you look at. The first thing relates to what type of ownership you're receiving, and are you getting voting control? In all likelihood, in the scenario that we're talking about, that sponsor member has a separate class of ownership, and that separate class of ownership is who controls the entity. That's a typical structure. So in all likelihood, you'll review, you're coming in as kind of an investor class with very limited voting rights. Now, there are a few categories of votes that state laws do require all members, all owners of your entity to vote on. Ensure that that's in there. But in all likelihood, when you review it, it will be clear both in the term sheet and in this operating agreement that you don't have any control, no voting rights. But you should still take a look at that if that feels important to you. If you're wanting to have a say, ensure that you're looking at that. One other main difference that LLCs can have is many are set up where if I'm investing my $100,000, I want to know the only thing that's at risk if this whole thing goes up in flames is my $100,000. There are many LLCs that are set up where that the sponsor members can come back to the investors in the form of a capital call and seek more capital. And I'm not saying that's good or bad. Many are set up that way because it's necessary in some situations. What I'm saying is you should know whether that's possible up front. So look for it. Related to risk, if you are investing as an investor member, you have no voting control. There should be a limitation on your any additional financial responsibility that you have for the investment. So my third bullet point here talking about personal guarantees is a real one. I have had five law firm clients within the last few months all come to me. They invested as limited members. They had no voting rights, no control. And unbeknownst to them, one of the things that they signed was a personal guarantee. And what that means is when I'm investing and I think, okay, I'm just putting in my $100,000, the thing that's at risk if the whole thing blows up is my $100,000. I might not get that back, but I was a limited partner. So that's the only thing that should be at risk. If you sign your name on a personal guarantee going to a bank, it is absolutely not the only thing that's at risk. Be very, very, very careful about going into a deal where you have no control, no voting authority, but you are signing a personal guarantee, because the people making decisions, that probably means that the people that are making decisions didn't have a financial condition that was sufficient to hold those guarantees, which means if things don't go well, they're coming after you. They're not going after the sponsor. So be very cognizant of that piece. And then the last thing I just want to mention is corporate governance rules are important, and non-attorneys can look for this too. If it looks like the sponsors or the key people that you've been talking to are treating this like their own personal bank account and their own personal investment, if things don't go well, if there's a lender on the project, they can do what's called piercing the corporate veil. So an LLC structure is put in place to shield the owners from personal liability, right? If the whole thing goes up in flames and the lender is going to foreclose on a property, for example, that's all that they have. All that they have are the assets of the entity or LLC. They can't come after the investors or anyone else unless they can pierce the corporate veil. And one of the main ways that happens is if those managers or the sponsor members are not adhering to sort of the LLC rules. And if they're treating it like their own personal account or personal investment, the likelihood that can happen and you have then personal risk is high. So just be watching for that. Presumably their operating agreement is going to include all of the necessary language that says this is an LLC. We're following all the corporate governance rules, et cetera.
So let me ask you a question. What would be a red flag that would alert you to them acting as such?
Yeah, if they are signing anything as their own name rather than as a member or manager of the entity, that's a first red flag. Any documents that they countersign they should be signing on behalf of the entity, not on behalf of themselves. That's one key way. Other things that you should have access to before you would invest are there should be corporate resolutions that are approving the acquisition, that are approving the loan, things like that, where it's not, hey, me, Lindsay, I'm out here and I'm going to sign this loan and I just decided I have the authority to do that. A one-page corporate resolution, which shows that the entity has approved that loan and given me signing authority, is all you need for down the road a court to say they were performing all the corporate necessities that they needed.
Do they need a separate resolution for each time they do it, or can one just blanket their role?
The way that I draft them is a single resolution will approve the creation of the entity, will approve the acquisition of whatever asset they're buying, will approve any loans that are coming on, and then give authority for any other things that are happening. So in the hotel space, I'm going to approve the franchise agreement with Marriott, for example. All of the big decisions and all of the big contracts that have to be signed, I bake all those one paragraph for each piece, and it's all done. If you're going to refinance 5 years down the road, for example, I do another corporate resolution at that point to approve the new loan or approve the refinance. So it's the small things that can make a big difference.
Yeah.
This might have helped you guys. I forgot that I have put this slide together. So as I was mentioning, while I was talking about kind of these legal pieces, when I'm advising, but other legal clients, but also my own real estate deals and nearly all of the investments that I both advise on and am a party to, the investment is structured like I have on the screen here. So you have an LLC. That LLC purchases whatever asset it's going to purchase. And that could be more, like I said, sometimes you have an entity that's purchasing multiple assets if it has sufficient financing and funding for that. And typically what you see is investors coming in two separate buckets. One are the investors who are providing some portion of the capital, and then the sponsor. One thing that I haven't noted yet, which I probably should have during the due diligence phase, when you're talking about due diligence on the sponsor entity itself or on the sponsor individuals, excuse me, one thing to think about and to ask, which is 100% an appropriate ask, is how much money are you putting in, sponsor? So in the real estate deals where I'm part of the sponsor, we've done everything from 5 or 6% in a really large deal that we did, all the way up to 25% of the equity. So a quarter of the equity was ours. And the rest we fill in with investor equity. In the deal that we are doing, that we're closing next month, we're providing actually more like half of the equity. So it depends, and none of those in that entire variation are right or wrong, but it is important to know that there's at least some skin in the game for the sponsor entity, that they're not just putting in, 25,000 of their own dollars and raising $10 million of other people's equity. You just want to make sure that that sponsor is highly incentivized to make the deal work.
We have a question. Somebody said, who would you hire to analyze a deal and protect the investments?
So I guess I get hired on the law firm side frequently. I don't know that you need, so an easy answer, I guess, is an attorney, but your attorney, I will go back to the comment that I made. You need someone who can analyze the financials. Not all attorneys are capable of doing that in every different scenario. And so I know that there are other underwriting firms that are out there that can be engaged. They might be a little bit more costly because, doing something on a flat fee is probably a little bit easier on the law firm side than it would be for a group like that. But there are many investment groups out there who perform this type of diligence, underwriting diligence, for a fee.
And a lot of the deals will perform all of this diligence and they will present it to you. And then you can go along and do a little bit of background check to make sure that the source documents that they've used are true. And then you can understand as they go through their own due diligence.
Yeah. All right. Moving on. I mentioned, hopefully this is quick. This relates back. I'm going to actually move back to this slide for a moment. I'm talking here about the trusts and holding companies and how they can be used to further minimize risk. The first two pieces of this conversation are related to who is putting something in a holding company or in an LLC. So I've already mentioned, when your investment entity is formed as an LLC, that acts as a risk breaker at that LLC level. In other words, if the assets that were purchased, which presumably will have a loan on them, if they fall through and the lender is trying to come up from the bottom of this capital, from the stack, and say, I'm foreclosing on the asset, but now I still haven't been made whole, and they start to try to come back up through this org structure that I have on this slide, that LLC is acting as a barrier. They can't get to the owners, except in very limited situations, which we've already talked about we're going to avoid. And so that LLC really does operate as a barrier to them trying to come back up. The other piece of it is, if you wanted in your investor equity class, and I have seen some investment groups and sponsors say, even in our investor equity class, we're going to have just for around 10 different investors coming in. We are requiring all 10 of you to form an LLC to bring in your investment. And all that does is add another layer of protection coming the opposite way. So, for example, say I, Lindsey, am an investor in the investor equity class, and I end up filing personal bankruptcy. That sponsor doesn't want the bankruptcy trustee to be able to take control of my ownership and then come back down the other direction toward the LLC and start trying to require changes to be made, for example. And so if I would have invested as an LLC, maybe they can take over that LLC, but it's another layer of barrier for that bankruptcy trustee to come back down and try to influence what's happening at the investment entity LLC. Now, I'll tell you, from my standpoint, I'm an attorney, so I'm going to say I love it. All right. As many barriers as you can have, that's great. I will admit that in the Acre Holdings real estate deals that we've done, we've never required our investors to form LLCs. We've got a lot of friends and mostly friends and family who are in there. I'm not going to go tell my aunt and uncle that they must form an LLC in order to invest with me. If they want to invest as individuals, they can go ahead and do that. I know them personally and I've known them my whole life. So I also feel pretty confident they're not going to be party to a bankruptcy proceeding, right? So it just depends on the structure that you're talking about. Anytime you're layering LLC on top of LLC, of course, there is additional risk reduction. So that more than anything, that's just what the point I'm trying to get across with that. The other thing that I have seen both in my practice and in my real estate business is having investors who create their own holding companies or trusts that hold all of their particular real estate. It does make it quite easy to have a single document to transfer. So if they're we do have investors who are invested in all now, this is their fourth deal, all four of our deals, they can send me a single transfer document, which transfers ownership in all four without having to do separate pieces if the same investment entity is owning all four of them. I'm not a CPA, but there also can be tax benefits, certainly if you have, if you are holding your investments in trust. So that's something that you should talk either to a tax attorney or to a CPA about, but that individual is not me. I know enough to be dangerous. So those are just sort of the additional components that you might want to think about while you're investing to protect your assets. And now I'm going to get into probably what most people thought the entirety of this presentation was about, but really, I firmly believe that all the upfront work is far more important than what you do once you own the property. The ongoing monitoring is the last piece. So what you need to be asking yourself, and then what you need to be following up on is who, after we close on the transaction, who's going to be performing ongoing monitoring? And is that ongoing monitoring going to be for a fee? Typically, the answer in structures like we've been focused on today, typically the answer to those is it's some party related to the sponsor is performing the monitoring. And yes, typically it's for a fee. Don't be afraid of that fact. It's not a red flag. It's a typical structure. It's considered an asset management fee. And typically you're going to get, or presumably you're going to be getting very specific services that are very detailed in exchange for the fee that they're taking. In my own real estate practice, there's an asset management agreement. So the investment company pays us according to that agreement, but it's got, I think, something like 15 bullet points of services that we're providing in exchange for the fee. What types of reporting do they provide? So from my standpoint, when I'm investing, I like to see information at least quarterly. So if I'm looking at a deal and somebody tells me we provide annual reports, this is me personally, I'm out. I care as much about my money as I do about many other things in my life, and I'm not willing to wait for a year to hear how things are going. Lots of people get comfortable with that cadence and perhaps even prefer that cadence, but I like to review information and know how things are going because in my view, if it's on a more regular cadence, if there's a problem, you can much more readily fix it. And I'm going to show you some examples of, in my investment group provides monthly information and then much more robust quarterly data dumps to our investors, but we also do provide monthly information, just a snapshot, and I'll show you some examples in a minute. Before I do that, I did want to mention though, state law typically requires very limited information to flow from the managers of an entity to the investors. However, your operating agreement is going to tell you what they should be providing. So ensure that you have reviewed that piece of the operating agreement. And if they're to be providing even unaudited financials on a quarterly basis or annual basis, ensure that you're keeping up with those details and ensure that you're receiving the information that the operating agreement required them to provide. So like I said, I just wanted to show kind of a snapshot of the various pieces of information that we provide. I'm not the kind of dark blue in the middle is the monthly investor update. As I mentioned, it's not a lot of information, but it's a paragraph on things that went well or went poorly at the hotel for the month. And then we provide in advance of the investment, we've provided a monthly budget for our hotels on an ongoing basis for the first 10 years of the property. We're unlikely to even own it for 10 years. But we do provide a comparison between how did the asset perform versus how did we think it was going to perform in that given month. Like I said, with just a little bit of detail. So just a snapshot, but on a more global basis, we will provide, it's like a 12 or 13 page deck that includes linked actual financials for the property on a quarterly basis. We also do host an investor portal. We use RealPage IMS, as you can see on the far left of your screen, where they can click into the deals that they are in, as well as any previous deals that we've had. Our group is open kimono in terms of how things are performing. We never want people to say, I'm disappointed and it's because you did a thing that I didn't know you were doing. And so we try to be as open as we possibly can be. Not everyone takes that tact, and that doesn't necessarily mean it's a bad thing. We do have investors who have never logged into our portal, and I'm sure have never opened any of our updates. And so, it just that piece of it ends up just being what you personally feel comfortable reviewing. Any questions about reporting? Okay. I would be remiss if we didn't at least talk a little bit about how I look at if I'm a general partner or sponsor member, as we've been terming it for this presentation, how do we protect assets on an ongoing basis? And I'm going to, the first two of these pieces are also, again, prior to acquisition of a property. They're focused here on real estate, of course, but the same types of reports can be pulled for any type of asset that you're purchasing. The first is, of course, a title opinion and title insurance. The worst thing in an investment world would have to be if you purchased real estate and then found out 3 years later that you didn't actually own it because you didn't buy it from the person who owned it. Title insurance is absolutely critical, and for the likelihood that you ever need it is incredibly low, but the benefit that you get from it in the event of an error is tremendous. It's not that expensive. Please, even if you don't have a lender, or even if you do have a lender who for some unknown, unfathomable reason in my mind isn't requiring you to have title insurance, you have to get title insurance. Have to. If you are investing in something where the sponsor has even contemplated not getting title insurance, you should not invest. That's just full stop. The other thing that we always get, and this is a piece that as a sponsor should negotiate when you're looking at real estate, a property condition and environmental report are also critical. And if you have a good relationship with the service providers who are providing that report, they will, because I've seen it because I've negotiated them in, provide warranty on their work. What I mean by that is they're providing you with a whole list of items prior to your acquisition of whatever type of real estate it is. Here is what we found, and here's how much money we think that you're going to spend in the first, call it 12 to 24 months, improving the property on the various things that we have found. You can negotiate into those agreements with them if they missed something or they were wrong about something, including an estimate. They will negotiate in warranties so that if something pops up that they should have caught that was within the scope of their engagement, that pops up within some period of time. I'm sure they won't negotiate the same for everybody, but I've caught something within the first 12 months, and that third party had insurance that covered it. We didn't have to use our own insurance. It can be incredibly helpful from an asset protection standpoint that you have preserved your own insurance policy and haven't had to make a claim, but have a material defect be able to be paid by someone else's insurance. It was critical. So just make sure when you're working with those third parties in advance of an acquisition of any type of asset, make sure that you're kind of holding their feet to the fire in terms of how much are they standing behind the work that they did.
So
And then
which
of course,
environmental reports are the most important?
phase one. Yeah. So we typically don't order anything beyond a phase one report unless it ends up being necessary.
Or it used
But
to be a gas station or something like that.
right. And actually, I say we've never had to do that. We actually, in our current acquisition where we're doing a development, we did do a phase two. And there was an apple orchard. And so there was some very limited contamination on like 2,500 square feet of a 40-acre lot. So it wasn't a major deal, but if it, for some reason, again, becomes a major deal, down the road, we have negotiated a pretty substantial right that we will have against the group that did that report for us. Anything else on that piece? Okay. And then of course, everyone knows insurance is pretty critical in my line of business. Often the insurance limits and things of that nature, all the terms are dictated by our lenders. And normally a lender is wanting to almost overprotect. And so occasionally we've thought that they've become overblown and will actually negotiate to reduce some the insurance requirements. But if you ever need your policy and you don't have adequate coverage, it's tough. And so there's a fine balance there. And when you are in the driver's seat as a general partner or sponsor, negotiating those limits, at the very least, understanding the risk and reward of the cost versus the coverage is critically important. I know we're running out of time here, but I will just say Florida is a really interesting issue. Tracy, I think it came up maybe a time or two while we were at the event where we met. And we actually this was now about 18 months ago, we had a hotel that was under contract in Sarasota, and we could not oh, hey, it's expensive, or oh, hey, the policy is doubled, or what. It wasn't a cost thing. We literally could not find a company to cover it. And our lender was saying, they wanted us to close on the deal so badly. They said, we are okay closing on the deal without coverage.
What?
And we just, you have to make a calculated risk. I wasn't comfortable not only putting my own money, but also my friends and family money into a deal where we legitimately could have been hit by a hurricane and had no insurance. And so everybody has to make those decisions for themselves, but they are real choices and they come up frequently. So just having a trustworthy group for limited partners, a trustworthy group on the sponsor side where and can trust that they're making calculated decisions is critical. And then, as I mentioned, ongoing monitoring on that piece. I become probably a little bit too detailed at all of the hotels that we own and are operating. I review the general ledger, every single line item, every single month. That's probably not required. But you can go from that to individuals who aren't even looking. And so just making sure that you're on my side of that spectrum will really ensure that on an ongoing basis, your asset is protected. And I think I have 5 minutes left in time for questions.
That's awesome. You covered everything. That was really, really good. I enjoyed that. And I'm glad that we asked questions as we went. That was relevant to what you're talking about. I don't see any other questions in the chat, but if anybody has any questions, now is the time to ask. It doesn't matter what the question is. One of us can answer it for sure. If we don't have anything, I don't mind wrapping it up. Did you have anything to add, Drew?
No, I just wanted to thank Lindsay for her time. I know she is extremely busy. And just the wealth of knowledge that you shared with everybody, we really do appreciate it. So, I will also, I'm gonna end this recording real quick.